The exercise of the oversight powers of this committee, I would like to propose that we go over the liquidation activities of the PDIC so that we will know what is happening. And they cited 500 banks, I think only 8, 590, and maybe the key banks that have affected the economy in a great way. So that we will see what is happening, what is the status, what happened to the assets, what are the prospects, and my point of interest, how are the stockholders, the owners of those banks doing right now, so that we can have a feel of how this liquidation activity is being performed by the PDIC, Mr. Chair. I would like to so move, Mr. Chair.
Is there an objection? Being none, motion is set by the committee. Now, is there any suggestion who should be the members of the...
No, I would propose that it be handled by the mother committee.
Okay.
We ask them to give us a briefing, starting with the major banks, maybe the biggest banks in this list of 590 or so banks that have been liquidated.
Okay, next hearing, we'll ask them already to prepare for whatever the information that we want to get. So, okay, we call for the next item on the agenda.
House Resolution number 2.37, resolution directing the Committee on Banks and Financial Intermediaries to conduct an inquiry and aid of legislation into the conservatorship and cooperate rehabilitation of proposal of Prudential Plans Incorporated and its compliance with RA number 9829, otherwise known as the Penal Code of the Philippines, sponsored by the Honorable Tanyada.
Deputy Speaker Tanyada has the floor.
Thank you, Mr. Chair. Mr. Chair, I filed the House Resolution 2537 to answer the growing concerns of the plan holders of Prudential Plans Incorporated that their interests were not adequately protected during the rehabilitation phase of the company. By way of a background, just very briefly, Mr. Chair, in 2009, the Insurance Commissioner revoked Prudential Life Incorporated's license to conduct business and disallowed it from selling new plans. Then on September 13, 2010, PPI was conservatorship. Eventually, it was placed in a state of suspension of payments by virtue of a state order promulgated by the conservator on February 3, 2012. On December 9, 2011, PPI submitted its first proposal for corporate rehabilitation. However, after the original rehabilitation proposal faced opposition from the plan holders, it turned in a revised rehabilitation proposal called the Balikbayan Program. The plan holders had their own rehabilitation proposal, and it was during the rehabilitation when they first sought my help, mainly to ensure that they would get a fair chance to have their rehabilitation proposal seriously considered by the Insurance Commissioner. Some significant developments have taken place since the events I described. Last September 19, PPI was placed under receivership. On October 19, by the directive of the Insurance Commissioner, PPI was ordered to be liquidated. Nevertheless, the company filed the application for review against the order of liquidation, so it looks like the issue of rehabilitation is still in play. What is our concern here as members of Congress? We enacted the pre-need code, yet it seems that the law has been unable to stave off the demise of one pre-need firm after another. There are 30 other companies under conservatorship approaching the situation in which PPI now finds itself. Hundreds of thousands of plan holders are involved. It is for their benefit that we now undertake this inquiry. I would like to focus on three questions. First, are our regulatory mechanisms, such as they are now, sufficient to provide for the supervision of pre-need firms? are the safeguards in the law working? With so many bringing firms in financial trouble, has the law been so far effective at protecting the plan holders? To hone in on the subject of this inquiry, what were the relevant factors in the financial decline of Prudential Life that could have been prevented or corrected by a sound law on the plan? Second, how inclusive and transparent was the process of rehabilitation? Were the concerns and inputs of the plan holders taken into consideration? Put in another way, where do the plan holders stand in relation to the insurance commissioner and his appointed conservator, receiver, and liquidator? Do these later named individuals act for the plan holders in something of a trust capacity? Or are the interests of government confined solely to the regulation of pre-need firms and not the protection of plan holders? Please understand, this is not an endeavor to assign blame. We are not here to point fingers. We are here to study this case so that we can improve the law and make the situation easier for plan holders of the 30 other firms under conservatorship. When I invited the Prudential Life plan holders to this hearing, I intimated that the inquiry may not benefit them as much as it will the plan holders in succeeding cases. So they understand that their participation is out of a sense of community with other individuals who find themselves in the same boat. And I thank them now for their generosity. We are also here to assist the Insurance Commission. If you remember, jurisdiction over the pre-need firms was transferred to the Insurance Commission very recently with the enactment of Republic Act 989. But by that time, these companies were already in trouble. We are fully aware here in Congress of the difficulty of taking over the regulation of these firms. And so far as the IC or Insurance Commission is concerned, what I would like to come out of this hearing is a clear picture of how we can help develop the law to help the Commission along with its particular work. For instance, are its powers under the law sufficient for the job of regulation? What difficulties, if any, did the Commission experience with the transition of the pre-need firms to its jurisdiction? Most important of all, we are here for the plan holders. Not because of their number, although that is very large indeed, but because it is their dreams, their plans, their futures that are at stake. We are here for those who dutifully set aside college money for their children, those who eat out savings for a pension plan. It is incumbent upon us to make sure the investment they have made does not come to naught. I thank my colleagues in the committee and the Honorable Chair for this opportunity. It is my hope that we can all work together and get to the bottom of this as such in order that we may make the situation better for the stakeholders in this case as well as those in succeeding ones. Maraming po salamat, Mr. Chair.